Today on Let's Talk Crimes, we're going to talk about no contest plea. This is a new subject for me as well. I don't know too much about it. So Frank, let me know, what is a no contest plea?
Welcome to Let's Talk Crimes with Frank again. No contest plea. Let me tell you first the different types of pleas, and then I'll get to no contest. And this way it refreshes your memory. You go to court, if you've been charged with a crime, you either plead guilty, you plead not guilty, which means you want to proceed to trial. And there are times in the state of Florida and other states where you're given the opportunity to plead no contest. What it means in lay person's language is that you're not expressly admitting guilt. You're not going to raise your right hand. You're not going to say, I am guilty. Mm-hmm. But you're going to authorize the court to proceed with the proceedings against you. And when that happens, in almost every single occasion, the court will then proceed and sentence you. However, you never said the words, I am guilty. But you are agreeing that the charges against you are valid, and the court will then sentences you.
So then why would you plead no contest if you're going to be found guilty anyway?
That's a good question, and even attorneys battle sometimes with their clients saying it makes no sense. I get it, and clients have told me sometimes I think it's more of a personal moral value, something about standing in a public courtroom and saying I am guilty. The people just have a problem saying. At the same time, they may admit that the charges against them are firm. They may admit that if they proceed to trial, they will lose, but they just don't want to say the words. That's one. But the more legal and common reason is that an admission under oath in any courtroom is admissible against you in any other courtroom. Sometimes you're being charged with a crime and you're also being charged for that same conduct in civil court. When that happens in the civil proceeding, they'll be able to use that admission against you. So that's a real legal benefit. Here you are, you took care of your criminal charge, and in civil court, they're not going to be able to use your words, I am guilty, and you could still defend yourself in another jurisdiction. I think that's really the benefit.
So is this still considered a conviction then, even though you didn't want to say the words, I am guilty?
The conviction comes not so much from what you said or what you didn't say. It comes from the judge making a finding of guilt, whether you admit it expressly or not. Once he finds you guilty and he adjudicates you guilty, it is a conviction. It absolutely is.
And is it common in Florida?
It is common. It's more common in misdemeanor courts. Misdemeanor courts are petty theft, small possession of marijuana cases. And it's not impossible in felony court. It's just not as common.
Have you seen it? Like, is this something one of your clients have done?
I've seen it on felony cases. I haven't seen it on first degree felonies. I know for a fact, and it's interesting, in preparation for some of these programs, I educate myself. There are jurisdictions in the state of Florida, and there are other states where in preparation for this program, I saw that even in homicide cases, it has been accepted. Most judges will not, and you require the judge's permission to take this kind of plea. I hope you enjoyed yourself again. I welcome all of you to Let's Talk Crime with Frank. I remind you, please go to our Facebook page, Let's Talk Crimes. Email us at letstalkcrimes@gmail.com and ask us any questions that I'm going to do my very best to make an episode for your questions. Thank you.
Guys, just you could also leave comments on the YouTube page as well, if that's easier for you. If you don't want to send an email or anything like that.
What you gonna do when they come?